Okay, good afternoon. It is 12:02, and welcome to the Local Land Use, Transportation, and Public Safety Committee. We have two bills on for today, MC 1124 and MC 1224. Before we dive into those, I want to let you all know that MC 724 was withdrawn. So we have only two bills left. Um, I did want to discuss 1124 today, but lesson learned, always read to the bottom of the email, because MDTA's email that I sent on to all of you had a $7.6 million figure for the speed camera program. I don't know where that figure comes from, so I need to talk to them. So let's hold any discussion on that bill until we understand what that fiscal note is. Is that okay with everyone? Or do you want to discuss it after we hear from State's Attorney McCarthy? What's the preference? Yes, Delegate Spiegel.
I'm happy to discuss it further later, Madam Chair, but I just wanted to note in your refreshing my memory about that line in that email. I remember when I saw it a few days ago, I wasn't clear on whether they were saying that that is the fiscal note on the bill in their view, or whether it was their estimate of the cost of other programs that were referenced in that email by MDTA, including their own efforts to enforce speed limits just through state police efforts and through putting up the enforcement speed monitors that are different than the speed
Right,
cameras. So I
right.
wasn't clear on that. So when we go back to them, maybe we'll get more clarity about that. But maybe that's the answer, and that it wasn't really them saying that the cost of the cameras themselves would be 7.6 million. But anyway, I agree we ought to wait and find out more.
Great, thank you. Anybody else, any other comments on MC 1124? Go forward or hold till we get clarification on that? Okay. So moving to MC 1224, that's the bill to enable folks in the state's attorney's office to collectively bargain. At the bill hearing, we heard from Senator Kramer and Gino Wren. So today we're giving State's Attorney McCarthy the opportunity to give us his position on the bill. So, John, the floor is yours.
Thanks. Thank you, Delegate Love. I appreciate that. Good morning or good afternoon, as the case may be to everybody. Thank you for giving me the opportunity to say a few things. First of all, let me just say a couple things. Number one, there's no one in the state that does this. And I think when I begin to go through some of my observations or things that I would ask you to consider, I'm going to go through a list of considerations and actually going to talk about the constitutionality of the legality of the proposal, which I think is very much in doubt. In any instance, I do think that the bill, because it would directly conflict with other state law as it now exists, does have an impact on all of the other 23 state's attorneys in the state. So you would have to amend 15416C, I think, to avoid any kind of a conflict if you did this, which I'm not urging you to do. I begin by telling you one of the biggest problems I have with it is that assistant state's attorneys are policymakers. And I believe the case law coming out of the Fourth Circuit indicates that collective bargaining agreements cannot bind policymakers. I am a policymaker. Anybody who runs for state's attorney is a policymaker, and the assistant state's attorneys that work for them are policymakers. There is a case called Barzilli versus Mosby in 2017. When Maryland ran for the state's attorney in Baltimore City, she ran on a particular platform. What she did when she got there is individuals who may have been loyal to her predecessor, may have campaigned for her predecessor, she fired them She got them out. And that case led to a great conversation about the nature of what assistant state's attorneys are, what their role is in running these offices, and the limitations, I believe, that exist under the law, and how you can modify the state's attorney's authority. This is reading very briefly 2 sentences from Barzilli. Elections mean something. Majorities bestow mandates. Elected prosecutors translate those mandates into policy, and assistant prosecutors implement those policies. In Maryland, assistant prosecutors' authority to implement vital public policy is not just a matter of convenience or custom, but of state law. I will tell you, I think as a constitutionally mandated officer who runs for office, and I am elected based on policies, whatever I do, or whatever anyone does in my office, they are policymakers, and I don't think they're subject to being made members of a collective bargaining unit. As a matter of fact, there is even reference in the same case, and I have it here for you to look at. They do, in fact, distinguish sheriff's departments because of the policymaking function that is unique to being an assistant state attorney, which is much different. Everyone in this office participates in vital policy making functions. They're making plea offers. They're deciding things on bond. They're deciding whether to try cases. They're implementing policies, but as policies makers, I do not believe that they can be unionized as a matter of law. I think there are principles that say that. I will tell you that when Marilyn cleaned house in Baltimore City, and she let a lot of people go, the Fourth Circuit upheld her authority to do that because she was a policymaker, and she was entitled to have people that were surrounding her in all positions that supported her policies. In a case 10 years prior to that, the case came out of Carroll County. There was an individual who was a victim witness coordinator, not an attorney, but that person was also disciplined and let go there. And the court upheld the authority of the state attorney to do that as a policymaker with those ideas. Look, we all run for offices based on promises or plans we have, whether you're talking about a truancy court program, whether you are talking about programs to address an opiate crisis in your community, which we've done, like Speak Up, Save a Life. People either support or oppose the policies and procedures that you have put in place. Besides the fact that I do not think it's legal to do this, and I think there is a distinction between the sheriff's department. I am a constitutional officer, just like everybody's listening to me in this delegation. What if you campaigned against an incumbent? You defeated them, and you were required to keep their staff upon arrival. Your secretaries, your advisors had to remain the same. How could you ever possibly do your job with a staff that was not committed to you, to your vision of what you wanted to do? I'm a constitutional officer. You are constitutionally elected officials. And you have much different policies, and people elect you because of the things you say. One of the things this bill also lacks is a fiscal note. I am telling you right now, and I've talked briefly I've talked to Gino about this, and I've talked to Ben. Look, this is not any kind of personal animosity against anybody here, because both of those guys are my friends, to be very honest. But I do not think that this is a legal thing for them to do. I also don't think they've considered the financial implications of this. I am not a labor expert. I don't have labor experts that I guess monitor or supervise my attorneys. I will tell you, the sheriff downstairs, and I talked to Sheriff Wee about this, he has hired a labor lawyer that works for them, and he's a full-time county employee. Well, so I think there's a fiscal note at the very outset of around $200,000 to get me a labor lawyer to look over. I have 200 employees. It's not a huge operation, but it's not a small operation. I have 200 employees. Who's going to manage that? Quite candidly, right now. So I need a labor lawyer, fiscal note. I also, I have supervisors right now that manage and do the evaluations of my lawyers. They also carry caseloads. If you take away and further burden them with other supervisory responsibilities, I might need 10 more lawyers because you're going to be dividing up the time that my people have to try cases. There's another fiscal note of maybe give me 10 more lawyers. Overtime. I looked at some of the bill. I don't know how overtime fits into this. Almost everybody here is salary. When my attorneys are in trial, and Ryan, I know you're a lawyer, and I know there's others people that are here that are attorneys. When you're in trial, you work to the task, and you don't go home at 4 o'clock or 5 o'clock in the afternoon. You might be here till 10 or 11. You dream about your cases. You wake up at 7 o'clock in the morning. You work weekends. Now, if they're also all of a sudden all my employees, whether they're support staff or whatever, because when we're in trial, my tech people are here, my victim witness coordinators are here, maybe they're 10 or 11 o'clock at night. I have tech people, we go to court, and a judge might say at 4:30 in the afternoon, here's some transcripts, but I want them redacted, or I want something done with a videotape. I got people here at 10, 11 o'clock at night working on that. Who's paying for that? Right now, this is an extraordinary group of men and women who work for me who are public servants that don't get paid overtime right now. Quite candidly, they might love the fact they'd get the overtime. Where's the money coming from? I would estimate that this bill would increase the budget of my office somewhere between 20 to 40% when you consider the fact I'd need a labor lawyer or somebody that has an expertise in this area that I lack. And I don't think there's anybody on my staff that has it. And then if we begin to have to pay overtime to people consistent with the overtime regulations of other county employees, I think that there would be millions. Somebody talked, you were joking. I think, Brian, you said something joking about a fiscal net of $6 or $7 million bucks. This could be millions of dollars. There's a cost here, and there's nothing associated with this bill that tells us about that.
State's Attorney McCarthy, I just want to clear the record. Neither Delegate Spiegel nor myself were joking about the fiscal note.
Oh, no.
Let's just be clear and correct the record.
I know that both Delegate Spiegel and you were very sincere and you're concerned about that fiscal note. I just say there's a fiscal note here too. It would ultimately come to the county. It wouldn't be on the state to pay this because we are county employees. That's who pays us. So it would fall to the state, but I don't think anybody's given any consideration to how would this change, how we would work here. It would be a fundamental change to the working model that we have here. I think, I am not aware, like some people might talk about what happens in other states. I'm just doing this based on the constitutionality, knowing what the case law is out of the Fourth Circuit. And also not knowing whether or not I'm a constitutional officer as you are. I think that has implications when you are basically dictating what constitutional officers have to do and who they can hire.
Sean, have you seen the opinion, because this issue was raised last year with respect to Sheriff Wee. Have you seen the opinion of the Attorney General's office on that?
As a matter of fact, the only thing I will say to you is I would invite the attention of everyone to the Mosby opinion, which I have here. And they
can you share that with us, please?
And the site for that, and let me see. Okay, the site here. It's a Fourth Circuit site.
Madam Chair, I was just reading it. I'm happy to put the link in the chat. That's possible.
I love it. Was it several thousand pages, Delegate Stewart?
It's actually a pretty short opinion.
Excellent. Thank you for dropping it in the link.
And they basically, they go, the delegation goes beyond, this delegation goes beyond, they're talking about the delegation of the authority to assistant state's attorneys in this opinion.
Thank you, sir. Appreciate it, guys.
Captain
Yes,
Flynn,
sir.
could
Thank you,
mute
sir.
yourself, please. Thank you.
Sorry.
Mr. State's Attorney, if you could wrap up, because I know one of our members needs to go, so I want to enable some time for discussion and Q&A.
In this opinion, they specifically distinguish that sheriffs are not like state's attorneys. It's in the case itself. And they distinguish the nature of what we do and distinguish it from that. bottom line, I think there's decisions we make all the time here, every day, about moving people around. I think based on the fact that we observe these people, we know what the demands are. We have 6 or 7 different specialty teams, and we move people to where we think they can best serve the people in the community. Maybe I should just take some questions as you suggest, Delegate. But I have a lot more input on this particular bill. I would invite your attention to that case.
Great. Thanks, John. Delegate Moon. Delegate Moon? There you go.
Sorry, thank you. And actually, I wanted to thank you, Madam Chair. I would defer to Delegate Spiegel if he has to leave and had anything that he wanted to ask first.
That's very kind of you, Delegate Spiegel.
Thank you, Delegate Moon. I don't have questions at this time, and I'm going to stick around for at least another 10 minutes or so if I can, and appreciate that, Delegate Moon, very much. Mostly, I just want to take a few minutes after our meeting to review the case law that was cited by the state's attorney. Thank you.
Thank you, Delegate Spiegel. Delegate Moon, back to you.
Thank you, Madam Chair. I have I guess, some questions for the state's attorney and just some points of reference, I guess, that I'm thinking about that maybe he could respond to. And let me just start with this. Generally, I think the county delegation, as I have observed it, has been supportive of, I don't want to speak for folks and say universal bargaining rights, but as these issues have come up on a one-by-one basis, the delegation generally has been in support of these efforts. So I just want to put that backdrop out there. So I am interested to hear if there are in fact legal or state constitutional impediments to doing this that would stop us even if we wanted to. So to that extent, if you could, again, send along things you think we ought to read, I will certainly dig into the materials. At least as to some of the distinctions you've made about sort of political and policy officers versus government workers, I would say I don't find that to be an insurmountable distinction. I worked at the county council years ago, and we certainly had political folks that came in with the office holders and the career government folks that had often similar functions, but were not tied to the political system. And we see the same at the federal level. And I would assume we could make such a division within your office through some means. So hopefully you would agree with that there either are or there aren't legal impediments. But as to some of the worker classification issues, I think that can be handled. So here are my points of reference. I believe we recently passed legislation creating a public defenders union. And I guess I wonder if we're creating, a lot of the issues seem to be similar, workload issues that the line attorneys raise as part of their reasons to seek unionization. And I wonder, those two sides of the government legal coin in those proceedings, if we're creating an imbalance. So that would be one point of reference. And then the other is as to the sheriffs, whether we aren't really just heading into a situation where, again, at least with respect to Montgomery County, we generally do seem to be making way for those who wish to seek union representation. And so I guess I would wonder what would be so different with your office and some of the, the sheriffs, the public defenders, the rest of the county government employees. Again, even I'm just talking about Montgomery at this point. Is it really so out of the norm?
Well, first of all, my background, I'm a card-carrying member of the Teamsters. I was a Teamster out of a local in Trenton, New Jersey, when I was going to college. My brothers are both retired union workers. Unions run very deep in my family, so I have a great allegiance for that. I will tell you, there's a tremendous distinction between, first of all, state's attorney and public defender. State's attorney is a constitutional officer. The public defender is not. State's attorney is an elected official who runs on a platform. The public defender is selected by a board, doesn't run on a platform. They are uniquely and completely different. I don't think there's any relationship between the two. I will say to you that, when there's a changeover in administration, in any of these offices, there are sea changes usually that occur within the personnel. A lot of the support people usually stick on. I say a lot of the support people, Delegate Moon, I think do in fact stay on a lot of these government agencies because that's the institutional memory that kind of helps them continue. But again, I think it can happen that way. But there are usually sea changes in the attorney staff in any office that changes hands. Go back and look at that same office 2 years into an administration, 50% of the people would be gone.
Anything else, Delegate Moon?
No, and I guess, would you agree that there's a division possible with respect to, having sort of career and political officials, if such a distinction were needed?
I wouldn't use the word career and political people. I think that the nature of anybody who is making policy decisions, to me, it's not. I wouldn't use the words or make the divisions based along the lines you suggested. I would make the lines based along. I would make the divisions between policymakers, decision makers, and non-policy makers. I think those artificial lines that you suggested don't really have any relevance to the world that I live in.
I guess I would beg to differ here, because where it gets confusing is I would agree with all those statements with respect to you. But anyone who works under you, I think there's a real question as to whether they're the policymaker or you're the elected policymaker. Well, my chief of staff, certainly, he's a very talented person, but I don't know if it would be fair to sort of, legally delegate some sort of significance to policymaking function there.
I think the Fourth Circuit case, to me, seems to suggest they don't make a distinction. They are carrying out my policy, and therefore, as carrying out my policy, they are in themselves policymakers. And we do 25,000 cases a year. I've got 200 people that work here. There are lots of following the policies. There's a lot of individual decision-making and policy being made individually by people every day in this office. They're making hundreds of decisions. The typical district court docket, 50, 60, 80 cases, they're making decisions all the time, hopefully consistent with the policies that we've set in place. But they're making arguments about sentencing and trial and bond and trial reductions and violations of probation. Those things are happening daily, and they are decision makers. I think I think the assistants are decision makers. I am a decision maker. I'm the elected constitutional officer, but they're carrying out what I've asked them to do.
Okay. This is a very interesting conversation, and I don't want to squander too much of my colleagues' time, but I will say I think that some of the distinctions you're poking at are not entirely clear, and it does also raise additional policy questions, like, is it a good thing for half of the county's prosecutors to churn in and out with every election, because there's been a change in administration? I think that's an interesting policy question in and of itself, what with the recruitment issues we're having. But okay, I will cede for my colleagues. Thank you.
Thank you, Delegate Moon. Apologies, Delegate Stewart. I'm going to bump you. Delegate Spiegel.
Thank you, Madam Chair. Just in a follow-up to Delegate Moon's questioning, I just wanted to throw out the question, which I think we could research rather easily, as to what other constitutional officers who are policymakers do or don't have to do with respect to certain types of support staff in their offices. and we could research that question and maybe get an answer. Maybe there are arguments, Mr. State's Attorney, why they should or shouldn't be analogous to your office, but I think maybe that would shed some light on this question if, for example, the comptroller's office or, the governor's office has certain categories of personnel who might be protected by collective bargaining rights and certain who might not, relative to their role in public policy making. And maybe that will help us with this discussion. So we'll try to look into that a little bit more. Madam Chair, I just wanted to note, with your permission, I'm going to have to jump off in just a moment, and wanted to say thank you to the state's attorney.
Thank you.
Delegate Siegel. Delegate Stewart.
Thank you, Madam Chair, and thank you so much to the state's attorney for being here. I think this is a really interesting conversation. I actually have a huge advantage here. I'm very glad that my constitutional law professor was so thorough, because we actually studied this Elrod Branty progeny around the First Amendment rights of political patronage appointees. So I feel like I'm back. It's been a decade, so I had to kind of like dust off some of it. We certainly did not study the Mosby case. That would have been after I went to law school, but it's really interesting. So a couple of things. So first, I actually sort of disagree with Delegate Moon, and I guess maybe agree with the state's attorney on one issue, which is I actually think it's a good thing for new state's attorneys to have the latitude to thin their staff and to make sure that people of their ideological or partisan persuasion work for them. Because I think that if the voters elect a state's attorney or any office, a prosecutor, or any policymaking body, I think that there is a case, a sort of lowercase d democratic case, for allowing that person we elected to execute their vision by having their people on board. But with that said, actually, this Mosby case makes me feel better, because it does not stand for the proposition that policymakers can't form unions. It actually stands for the proposition. So it's based on this case, Elrod versus Burns from 1976. And what Elrod said is that there is a narrow exception to the general First Amendment rule. The general First Amendment rule is that you cannot fire political or public employees for their political affiliation or their political beliefs. That's the general First Amendment rule. But then they carved out an exception and said, actually, if the employee is a policymaker, not the employer, but if the employee is a policymaker, then that's a narrow exception. In that case, in Elrod, it was about sheriffs. It was a Democratic elected sheriff was deemed not a policymaker, to your point, State's Attorney McCarthy. In Branty, which came a few years after, they actually ruled that public defenders, assistant public defenders, deputy public defenders, were not policymakers. I'm not so sure if that's the right decision. I could see that being reversed today, but that's how they came out. And then you're right. In this Mosby case, they said that assistant prosecutors, in contrast to deputy public defenders, which is a little weird, but they said they were policymakers. But that doesn't mean they can't unionize. It doesn't mean, it's not the case that if you're a policymaker, you can't have collective bargaining rights or you can't have a union. That's not what the case says. It says that whether there's a union or not for the public employee, they can't be fired under the Constitution for their political affiliation. What I interpret that to mean is if we pass this bill, we could, I think, have our cake and eat it too, because we could get the benefits and the wages. And of course, to your point, to Attorney McCarthy, obviously there are cost increases associated with that too. And that's something we have to discuss, but I'm going to put that aside for now. We could kind of have our cake and eat it too, because we get the benefits and the wages, and maybe these line attorneys, maybe, they're being overworked or overburdened, or their caseload being high or whatever. We could sort of maybe start to solve some of those issues that have been brought by Senator Kramer, but we don't have to worry about the problem I mentioned at the jump, which is that state's attorneys' hands would be tied in terms of hiring and firing. Because my interpretation of the Mosby case is, yes, policymakers can unionize. In fact, there are a number of prosecutors' offices across the country that have unionized. There hasn't been a single case I checked that's been filed on constitutional grounds saying that they couldn't. There have been a number of PD's offices, not just in Maryland, but across the country, that have unionized. No one has tried to stop them based on First Amendment grounds, even though they were deemed not to be policymakers. But either way, no one has filed suit. And similarly, legislative staff, for like even state legislators, have begun to unionize. I would argue that they're policymakers too, our legislative staff. I certainly, devolve a lot of my own authority to my chief of staff to make various policy-related decisions. But no constitutional challenge has been filed in those issues as well. So my reading of these cases, and Senator McCarthy, State's Attorney McCarthy, I gave you a demotion. I'll let you respond and see how I'm wrong. I think you're a much better attorney than I am. But my take on this is there's no constitutional provision or prohibition in the First Amendment or otherwise on policymakers unionizing. That's not an NLRB decision. That's nothing. Now, supervisors sometimes do have prohibitions under labor law, but there's no policymaker exception to collective bargaining rights. There is an exception for when people have First Amendment rights not to be fired for political views, and policymakers are not afforded that First Amendment protection. So, in summary, my view of this case law is we could pass this bill constitutionally. Assistant state's attorneys could constitutionally exercise collective bargaining rights. They could bargain on wages and benefits. But I think that your successor, State's Attorney McCarthy, whether he or she was to your left and wanted to bring in a bunch of PDs to staff the office, or whether they were to your right and they wanted to get tougher on crime, I think regardless of what the collective bargaining agreement says, I think they would have latitude to do that based on the Mosby decision. In other words, that makes me more likely to support the bill because my concerns at the beginning are more allayed. I'm not as worried about elected people being able to execute their vision because the Mosby case tells me they can do that regardless of the collective bargaining agreement because collective bargaining agreements are always subservient to the Constitution. Anyway, that is my long-winded explanation of I think what's going on here with the case law, but please tell me where you think that I have erred.
Actually, I'd give you an A. I think your recitation and your analysis. I was jealous because I think you said it better than I in terms of because I was rushing to go through some of the case law, knowing that my time was limited. So I do not think you misstated anything relative to the law at all. I will tell you, obviously, I am concerned about the costs. And the right now I have the authority to hire or fire at will. And the merit protections, if we have, and we are having struggles getting attorneys here more so than ever. Look, I've been here in eras when we got 100 applications for every job. Now I spent the entire weekend and I think Delegate Love knows this. I was downtown trying to hire lawyers from all over the country, recruiting all weekend because that is a challenge for us right now. I am concerned of merit protections and grievance procedures and appeals that would cost me my lawyers. So that I could, there's other issues about the practical way in which this could impact the way the office runs. So.
Thank you. Delegate Wu?
I'm trying to raise the hand and couldn't find.
I saw you waving. I got you.
Yeah, that's like face recognition. So recognition. Okay. Thank you very much, Chair. I think my questions come back to the constitutionality question, right? I would trust like more objective opinion from somebody, like a third party, independent party, look at this constitutionality question instead of the politicians. Like it's not really objective, right? So is there any way we can get that?
Yeah, I think that's a wonderful idea. I appreciate that question. I will tell you that we have been speaking to members of the Attorney General's staff and seeking their opinion. So, I mean, to some extent, the suggestion of asking the Attorney General to weigh in on this, we've been doing the same thing, trying to catch up and asking people within that office to advise me about what some of the issues they see regarding this bill. And so I'm not opposed to that. I think that's a wonderful idea.
Delegate Wu, we can ask the attorney who is assigned to us in the state's attorney's office for an opinion on that or advice on that. So
that'd be great. I really appreciate that. Thank you, Chair.
Get that done. Great. Any other questions for State's Attorney McCarthy? Yes, Delegate Stewart.
I would just conclude by again thanking you for your time. I'm like I said, I'm not really. I'm kind of undecided on the bill. I mean, I think to Delegate Moon's point, I mean, I think this is something that generally the the delegation has supported. At the same time, I mean, I think that, we need to take a look at the cost issue of this. Just because I think that we don't have a constitutional problem doesn't mean that I think that this doesn't bear, some scrutiny. So I'm looking forward to continue delving into it, but I do appreciate your time.
Thank you, Delegate Stewart. And I echo that. Thank you, State's Attorney McCarthy. Really appreciate your time.
Thank you. very much.
And
Thank you.
we'll circle back if we have any questions. And thanks so much again.
Okay, thank you. Have a great day.
You too. Okay, members. Interesting stuff. Interesting stuff. Anybody have any questions, comments, thoughts? We will definitely, Delegate Wu, to your point, I'll reach out to and get that advice letter on this, just like we did with the sheriff's office. And anybody else, any thoughts on this? Well, I'll throw in, thank you, Delegate Stewart. I always appreciate when you chime in. I appreciate the constitutional law lesson. That was actually very helpful. I do wonder, as you said, about the fiscal impact of this. Mel, can you and your team, is there any way you all can give us some assistance on that?
So, Madam Chair, I'm handling this bill.
Hi. Yes.
Hi. Madam Chair, I can handle this. So, as you know, this bill, it makes the county government, makes the county executive the employer for the purposes of wages and compensation, and it makes the sheriff the employer for other purposes. So, any fiscal analysis would have to analyze both sides, impact on county government versus impact on state's attorney's office, and that's the model sheriff's office. So if you want to do a fiscal impact analysis, I'm just looking to, are you saying DLS did not do one yet?
No.
Okay, because we're happy to work with them. And it would be combining data from both sides.
Thank you. Delegate Stewart?
Thank you, Madam Chair. Kathleen, I was just thinking what would be, I think, even easier to put together, before we get the fiscal analysis of the bill itself, is this is such an empirical question because we've done so many of these collective bargaining bills in different units of county government before. It seems like it would not be hard to sort of look at the sheriff's office or the PD's office or any number of different, maybe not completely analogous, but other units, and look at cost increases year over year before and after collective bargaining, and look at to see what that increase looks like. Do you think that that's data that's readily available, or is that pie in the sky?
I can certainly ask, no problem at all. Your best analogy here is the sheriff's office because it is that state constitutional officer. It does have that split. It's the only setup now that has the county executive as the employer and as essentially the entity that bargains for wages and compensation, and the sheriff's office having everything else. Plus, there's then complex negotiations that have to go on about who's in the merit system, who goes through the merit system. There's all sorts of complex issues. So I can definitely ask if there's any data on that. It's quite possible there isn't because it's been so long.
Yeah, right. Because when would that have gone into effect?
I'll have to check. I've got the state statute that created this scheme for the sheriff. I'm just looking at all the chapter laws. It goes way back. So it goes way back to 2000. It goes way back. So I'm not sure at what point this scheme was created.
Okay, got it. All right. Well, maybe it will be helpful, maybe it won't. But absent an actual fiscal analysis on our end, that seems like the thing that we could get the fastest. But
right.
I guess we could call around. I know that there are some prosecutors' office in like Pennsylvania and a few other places. I guess we could call them, but that's going to take some legwork. But anyway, yeah, thank you.
Sure. Would you like us to work with DLS? Would you like I'm just sort of following this. Whenever DLS does a fiscal impact statement on a local bill, we work with them to provide any input. Would you like us to work with DLS? You want to ask them to do that? Would you like to do us to get informal information back to you?
Let's start with informal information. Let me check with Chair Polakovich Carr, because I don't know if we've passed the time for requesting of DLS.
Well, I
there
guess
was a deadline before for local
Okay.
bills.
Got it. Okay.
Yep. Delegate Moon.
Thank you, Madam Chair. Just one thing, if we're going to start pulling numbers like this, I would just ask that we pull some other agencies or divisions for comps and controls, so that if it's the case that, because costs went up on everyone, union or not recently, so I just want to make sure that we don't attribute whatever the last 8% from the last couple of years to the unionization, when in fact it was a common effect. So just one word of caution on the data.
Thank you very much. Ralph?
Just to give context on that local fiscal note process, as of right now, the deadline to request a formal fiscal note on a local bill has passed. So, and we usually as a delegation select 5 or 6 bills during the drafting process that we anticipate would have a fiscal cost. This didn't end up being one of them. So at least if we wanted a formal fiscal note from the office at DLS, we wouldn't be able to do that at this time.
Thank you. That's helpful. Delegate Stewart.
Thank you, Madam Chair. Just a question for Ralph. Is my memory correct that we'd have to basically pass the bill to get a fiscal note? Like once we pass it, it just becomes a House bill. Is that not how it works?
Yeah,
yes. Once.
But my understanding is that deadline, I could be wrong, Ralph, but that deadline is the bills that you wanted a fiscal impact on before the public hearing.
Yeah, before we pass anything, right?
Yeah, but that's before the public hearing. I think you have discretion to ask DLS right now.
Kathleen, that was for the local bills. So, and that date is passed. So if this is passed out of the local delegation, then it becomes a House bill and DLS will give us a fiscal note.
Yeah, I defer to you all. I defer to you all. I think there's discretion that DLS has, but I defer to you.
Thank you.
My understanding is that Chair Love, you are correct. So the preliminary fiscal note that would be ordered for a local bill, that deadline has passed. So then to get the next fiscal interpretation, we would have to send a favorable recommendation to the committee with the House bill, as I understand it.
Sort of a perverse incentive.
I had that same thought.
Yeah. Well, I just have one other comment, if I could.
Sure, go ahead.
I was just going to say to Delegate Moon's point. I mean, I think he's absolutely right that we need to any data we're able to get back empirically to try to make a decision before we issue a favorable or unfavorable report on this. We have to take into context whatever the costs are. But what I'll also say is obviously there is a taxpayer cost to pay if wages and benefits went up significantly, and that is something that the county government would have to swallow. And I think it's also incumbent on us to think about, assuming there is a large increase, what value we gain from that. And I think that one could make the argument that we, being in an area where we compete for attorneys with the federal government, that we could potentially get some bang for our buck, at least if wages and benefits did go up. Even if the county government and taxpayers had to swallow that cost, we, in other words, might get more capable, not that there aren't committed and capable attorneys already serving as assistant state's attorney, but it seems like we would compete even more than we already do for the best and brightest, not only with the federal government, but also with the Howard counties and the Frederick counties and the Prince George's counties of the world, which I know pay either about the same amount or maybe a little bit less than we do. So that's another thought as well. In other words, even if we do find that the cost would go up, maybe that's not necessarily the end of the world if it means that the folks that are kind of on the front lines of prosecuting the criminal laws of Montgomery County are well compensated and we can hire the best.
Interesting point. Thank you. Any other members have any other thoughts? questions, comments? Okay, so if I have this correctly, I'm going to reach out to the Attorney General's office and ask them for advice on the constitutionality question. And then Kathleen, you all are going to take a look at some of the fiscal numbers that you can find. I know we also, Delegate Moon, I'm trying to figure out how we find those other numbers. So I'm not quite sure where else to go for those other numbers. To
Yeah,
Delegate Stewart's
that is
point,
a
it's
good
somewhat-
question. We need some way to gut check
Yeah.
any increases within the newly unionized units versus the rest. I guess we'll just have to park that.
Yeah.
Madam
Anything
Chair, just to be clear, what we can give you is fiscal impact from the county side. It's really the state's attorneys that's going to have to give you fiscal impact estimate from that side.
Yes, thank you.
Okay.
And State's Attorney McCarthy, if you're still on and can hear us, if you can send us any financial information, that would be helpful as well.
He is
Anything else?
Madam Chair, but I will request that from him.
Yeah,
Perfect. Thank you.
Lisa Russo is the head of my budget, and my budget, I have an in-house budget analyst, and I can ask her to begin crunch some numbers for you.
That is very helpful. Thank you. Members, anything else that we need to look into to move forward on this bill? Okay. Great. Well, thank you all for a really robust discussion and conversation on that. Anything else for the good of the order? All right. Well, my great hopes to have every meeting be our last meeting and clear the decks continue to be dashed. So to be continued. Thanks, everyone. I will let you know when our next meeting is. Plan on next week, but that remains to be seen. We got to make sure we have all the information.